Good afternoon, everyone, and welcome to the annual Brennan Center Jorde Symposium lecture. It's a joy to see so many of you here for what promises to be a thought-provoking discussion. The Jorde Symposium was established in 1996 to sponsor top scholarly discourse and writing from a variety of perspectives on issues that were central to the legacy of William J. Brennan, Jr. The symposium is named in honor of Thomas M. Jorde, a former clerk to Justice Brennan and a longtime member of the Berkeley Law faculty. I want to take a moment to thank Mr. Jorde for his generosity and for being with us today. This program is a distinctive collaboration between the Brennan Center for Justice and Berkeley Law. We deeply value this long-standing partnership, and I want to extend a special thanks to John Cowell from the Brennan Center for his continuing leadership and support. One of the unique features of the Jorde Symposium is its structure. Each year, the honored lecturer delivers the same talk twice, once here at Berkeley in the fall, and then again in the spring with different distinguished commentators at each site. The lecture, both sets of commentaries will appear later in the California Law Review, continuing this tradition of rigorous and public-minded scholarship. This year's lecturer hardly needs introduction. Erwin Chemerinsky is the Dean and Jesse H. Choper Distinguished Professor of Law here at UC Berkeley School of Law. Before joining Berkeley, he served as the founding Dean of UC Irvine School of Law and also taught at Duke, USC, and DePaul. He's authored more than 20 books and more than 200 law review articles, including his most recent book, No Democracy Lasts Forever: How the Constitution Threatens the United States, published in 2024. Dean Chemerinsky is also a frequent advocate before appellate courts, including the United States Supreme Court. And in 2022, Dean Chemerinsky served as the president of the Association of American Law Schools. We are also honored to be joined by two distinguished commentators. Professor Khiara Bridges of Berkeley Law is one of the nation's leading scholars on race, class, and reproductive rights. Her scholarship has appeared in Yale Law Journal, Harvard Law Review, Stanford Law Review, Columbia Law Review, and of course, the California Law Review. She is the author of 3 acclaimed books, with a 4th, Expecting Inequity: How Maternal Health Crisis Affects Even the Wealthiest Black Americans, forthcoming from MIT Press in 2026. And Professor Lawrence Solum joins us from the University of Virginia School of Law, where he is the William L. Matheson and Robert Morgenthau Distinguished Professor of Law and the Douglas D. Drysdale Research Professor of Law. Professor Solum is an internationally recognized legal theorist whose work in constitutional theory, procedure, and the philosophy of law. His interests include the intersection of law with the philosophy of language and with moral and political philosophy. His articles on constitutional originalism have shaped contemporary thinking about the great debate between originalism and constitutional theory. Professor Solum's original theory of the fundamental nature and purpose of law, virtue jurisprudence, has been debated and discussed in Asia, Europe, and North America. He also works on problems of law and technology, including internet governance, copyright policy, and patent law. In today's Jorde lecture, titled Against Constitutional Theory, Dean Chemerinsky will argue that for the last half-century, constitutional law scholars and judges have pursued an impossible goal: developing a theory that both constrains courts and reconciles judicial review with democracy. He contends that this quest cannot succeed, and that, in fact, it may distract us from the real questions at the heart of constitutional decision-making. Following the program, I invite you all to join us for a reception in the donor lobby, where you can continue the conversations with our speakers and our colleagues. Please join me now in welcoming Dean Erwin Chemerinsky.
Thank you so much for that very kind introduction. I want to start by thanking Tom Jorde and John Cowell for bestowing on me this great honor of delivering the Brennan Center Jorde Lecture. As I look to have done this lecture over the past years, it feels like being chosen for a Hall of Fame, though I worry it may be, as you look at it, a Sesame Street, which of these does not belong. I want to take a moment in that capacity as Dean to thank Tom and John for making all of this possible for so many years. Tom, the Jorde Lecture really is a signature event here at Berkeley Law, thanks to you. And John, I am so grateful to you and the Brennan Center for the continued partnership. I hope that this is a collaboration that will continue for many years into the future. And I want to take a moment to thank Khiara Bridges and Larry Solum for engaging with my work and being commentators today. Khiara is my wonderful colleague here. I believe one of my best accomplishments as dean was helping to recruit Khiara to Berkeley. And Larry and I have known each other for over 50 years since we were competitor college debaters in the mid-1970s. The debate topic that year was, quote, resolved that the powers of the presidency should be significantly curtailed. The affirmative case, the proposal that I advanced that year, was that to take away any control of the president over the gathering of statistics, like unemployment and labor statistics, something that seems prescient in hindsight. As was mentioned, the title of my lecture is Against Constitutional Theory. In 1962, Yale professor Alexander Bickel wrote the book The Least Dangerous Branch. Many have credited it with the beginning of modern constitutional theory. I believe that Bickel set constitutional law off on a futile course, and that I believe that it's greatly distorted constitutional decision-making ever since. Bickel's premise was that judicial review is, quote, a deviant institution in American government. He spoke of, quote, the counter-majoritarian difficulty. This is the problem, he said, that arises when you have unelected judges striking down the actions of elected government officials. Ever since Bickel wrote that book, constitutional theory has been preoccupied with how to reconcile judicial review with democracy, and the interrelated goal of how to make sure that judicial decision-making isn't a product of the values of who's on the bench. As I was looking through the list of prior Jorde lectures, many who have stood at this podium have spoken about constitutional theory. In fact, in the fall of 2002, I was invited to come to Berkeley to be a commentator on Dean Larry Kramer's paper, which was about popular constitutionalism as a way of trying to address the counter-majoritarian difficulty in defining the role of the courts. My thesis is that constitutional theory, as it has been practiced for over 60 years, is a futile quest, and moreover, that it's an undesirable one that does great harm to constitutional law. This afternoon, I want to present 4 points. First, I want to start with a brief history of contemporary constitutional theory. Second, I want to argue why constitutional theory is futile in trying to achieve the goals that Professor Bickel set out over 60 years ago. But I want to go further and then suggest to you, third, that constitutional theory has been done is undesirable, indeed harmful. And then fourth and finally, I want to briefly sketch what would it mean to have constitutional law without constitutional theory. Let me then start with the first point, a brief history of constitutional theory. There's certainly been a debate over judicial review since the beginning of American history. The text of the Constitution says nothing about judicial review. It wasn't discussed at the Constitutional Convention. Not surprisingly, the conclusion from Marbury versus Madison, giving courts the power of judicial review, has been debated ever since. But if you look at scholarship from the 19th century, it wasn't about the method of interpreting the Constitution. Even when the court handed down very controversial decisions, it wasn't a methodological debate. The Supreme Court's decision, tragically in Dred Scott versus Sanford in 1857, that enslaved individuals were not citizens, even if born in the United States, that the Missouri Compromise was unconstitutional, was very controversial. But if you look at Abraham Lincoln's critique of it, it wasn't methodological. It was very much a disagreement with the substance of the decision. Constitutional theory, though, didn't begin with Alexander Bickel. One of the famous early articles about it was in 1893 by Harvard professor James Bradley Thayer in the Harvard Law Review. And what he argued was that there should be judicial restraint, that if courts were active, then other elected officials who take an oath to uphold the Constitution wouldn't follow that oath. That if there was the overhang of judicial review, then legislators, presidents, state and local officials would just defer to the courts. From the 1890s to 1937 was a period of constitutional history known as the Lochner era. During this time, the Supreme Court declared unconstitutional over 200 federal, state, and local laws, especially protecting workers and consumers. It's striking, though, that even during this time, there wasn't a debate over the method of interpreting the Constitution. To be sure, there was strong disagreement with the value choices of the court. There was disagreement over whether or not freedom of contract existed or was just an illusion, whether equal bargaining power justified legislative regulation, over the scope of Congress's power under the Commerce Clause. But relatively little of that debate was what today we would call constitutional theory. In my introduction, I attributed the beginning of constitutional theory to Bickel's book in 1962. I actually think it started a bit before that, and I think it and Bickel's book very much were derived from a desire to criticize the liberal activism of what they perceived as the Warren Court. I would start just a few years before Bickel's book with Professor Herbert Weschler's 1959 foreword in the Harvard Law Review titled Toward Neutral Principles of Constitutional Law. Harvard professor Cass Sunstein has described this as the origins of our modern debate over constitutional theory. At one point, Weschler's article was the second most frequent cited law review article in all of American history. And what Weschler argued is that the Supreme Court should have neutral principles that it follows for decisions. At first blush, this seems unobjectionable. Who's for unprincipled judging? And we always want our judges to be neutral. And yet on reflection, Weschler's article is unsatisfying. After all, what is a neutral principle of constitutional law? How are we going to find such neutral principles? And if one reads to the end of Weschler's article, it's disturbing. The last part of the article uses his desire for neutral principles to criticize the Supreme Court's decisions advancing racial equality. He focuses on Shelley versus Kramer from 1948 and on Brown versus Board of Education. Bickel follows Weschler just a few years later, and in Least Dangerous Branch, Bickel criticizes Weschler's neutral principles. Bickel had been a law clerk to Justice Felix Frankfurter. Frankfurter was very committed to judicial restraint. Frankfurter went on the court, was thought of as a liberal. When he retired in 1962, he was thought as the most conservative member of the Warren Court. We often forget that his judicial restraint led him, in 1962, to write a vehement dissent in Baker versus Carr, where the Supreme Court held that there can be challenges to malapportionment of legislatures. When Earl Warren was asked what was the most important decision during his time on the court, he pointed not Brown versus Board of Education, but to Baker versus Carr. And Alexander Bickel very much picked up the mantle of the justice he clerked for. In Least Dangerous Branch was a criticism of what he perceived as judicial activism, a plea for judicial restraint. As I said, the core of the book was claim that judicial review is a deviant institution in American society, and how to reconcile it with judicial review and democracy was all about the counter-majoritarian difficulty. Bickel's work was certainly influential in the years that followed it. And in 1971, another Yale law professor, Robert Bork, wrote an article in the Indiana Law Journal, based on a speech he gave at that law school, titled Neutral Principles in the First Amendment. He consciously had picked up from the title of Herbert Weschler's article. And in it, Bork argued that judicial review is inconsistent with democracy as majority rule, and that the only way to reconcile judicial review with democracy is if the justices follow the original intent behind the Constitution. For him, that was the framers' intent. Many, including my colleague John Yoo, attribute Bork's article to the beginning of what today we call originalism. Just a couple years later, Harvard professor Raoul Berger wrote a book, Government by Judiciary. And it was openly a criticism of the Warren Court's decisions about equal protection, saying that they failed to follow the framers' intent. The 1970s was filled with articles responding to Bork and Berger and debating the desirability of Warren Court decisions and a Warren Court methodology. In 1980, Harvard professor John Hart Ely published Democracy and Distrust. I think it's one of the most important works ever with regard to constitutional theory. Ely begins the book, like Bickel did, by defining democracy as majority rule and saying that judicial review is legitimate only if it can be reconciled with majority rule. Ely rejected both what he called interpretivism, today we would label it originalism, and non-interpretivism, today we'd call non-originalism, and he developed his own theory of constitutional interpretation based on the role of the courts in perfecting the processes of democracy. At the same time, other influential books were written, all focused on answering Bickel's critique, focusing on how to reconcile judicial review with democracy. Yale professor Charles Black, Northwestern professor Michael Perry, each published influential books saying the only way to reconcile judicial review with democracy is to allow Congress to restrict the jurisdiction of the federal courts. In 1973, the Supreme Court had decided Roe versus Wade. Conservative critics wanted a methodological approach for criticizing that decision, as well as more generally, as Bork and Berger did, criticizing the substantive results of the Warren Court. Originalism provided that answer. In 1985, then Attorney General Edwin Meese, a graduate of this law school, gave a speech to the Federalist Society saying the only legitimate method of constitutional interpretation is for the courts to follow the original intent behind a constitutional provision. The Federalist Society, which was beginning around the same time, embraced originalism as a method of constitutional interpretation. 2 years later, though, the debate over constitutional interpretation emerged in the public arena. President Ronald Reagan nominated D.C. Circuit Judge Robert Bork for the Supreme Court. Bork had impeccable credentials. As I mentioned, he'd been a Yale law professor, he was the Solicitor General of the United States for a time, and a D.C. Circuit Judge. The opposition to Bork was very much focused on his originalism, focused on how Bork had said that there's no right to privacy in the Constitution, that cases like Griswold versus Connecticut and Roe versus Wade were wrongly decided. Bork said in that 1971 article that the only speech to protect in the First Amendment is that related to political expression. Bork had said that there should be no protection under equal protection against sex discrimination. Bork faced an insolvable dilemma. Either he would adhere to those positions at the confirmation hearing and be rejected because it was regarded as unacceptable, or he could change his positions and be accused as confirmation conversion. 58 senators voted against Robert Bork's confirmation, the largest number ever to vote against the nomination of a Supreme Court justice. It was an emphatic rejection of originalism. But slowly, originalism grew in acceptance on the Supreme Court and among academics. When Antonin Scalia first went on the Supreme Court, he didn't purport originalism as his theory. If you look at his decision in 1989 from Michael H. versus Gerald D., he said constitutional interpretation should focus on tradition, stated at the most specific level of abstraction. But over the next several years, Scalia came to embrace originalism. He was joined by Justice Clarence Thomas. And for a long time, they were the only two justices on the court to embrace originalism. But as we tell the story of constitutional theory, the 2016 election was crucial. If Hillary Clinton had won in 2016, and she had picked 3 Supreme Court justices, there would only be one originalist on the court, Clarence Thomas. Originalism would have been relegated to a critique used by conservative law professors of decisions in the Supreme Court they didn't like. However, since Donald Trump prevailed, he picked 3 justices. He picked Neil Gorsuch and Amy Coney Barrett, who were self-avowed originalists. It was uncertain for a time whether Brett Kavanaugh was also an originalist. He resolved that doubt in June of 2024 in a concurring opinion in United States versus Rahimi. He said there are only 2 ways for justice to decide cases. Either they follow history or they impose their own values. He said thus, it has to be an originalist approach to the Constitution. Now I want to be clear, constitutional theory doesn't have to be just between originalism and non-originalism. There are many other theories that have been developed, some that I've alluded to. But increasingly over the years, the debate over constitutional theory has been this debate between these 2 warring camps, originalism and non-originalism. Well, this leads me to the second part of my remarks, in which I want to argue that it's a futile quest that Bickle put us on over 60 years ago. Remember, Bickle had 2 goals. First, saying that for judicial review to be legitimate, it to be reconciled with democracy defined as majority rule. And second, and it's interrelated, that justices can't impose their own values in decision-making, because that would be inconsistent with democracy. Neither of these goals can be achieved. None ever has been, none ever will be. Let me talk about the first, reconcile judicial review with democracy. The Constitution is inherently anti-majoritarian, so any decisions that enforce it are also going to be anti-majoritarian. No one alive today voted to approve the Constitution. I doubt many of us in this room had ancestors in the country in 1787 when the Constitution was adopted. And we can't take the absence of amendment as acquiescence by the majority, since it takes a supermajority of both houses of Congress in the states to approve it. The failure to amend it certainly doesn't necessarily reflect a majority sentiment. The Constitution was designed from the very beginning to limit what the majority in society could do. I always ask my students on the first day of constitutional law, what makes the Constitution different from all other laws? And the answer, of course, is any other law can be changed by that session or a future session of the state legislature or of Congress. But change the Constitution requires a far more elaborate process. And then I ask the students, why would a nation that thinks of itself as democracy constitute itself in a document that's so difficult to change? And the answer is that the Constitution was meant to protect our most important values from being easily changed. In the words of Harvard professor Lawrence Tribe, the Constitution is an elaborate edifice to make sure that our short-term passions don't cause us to lose sight of our long-term values. And so, separation of powers, federalism, individual liberties, equal protection are put into the Constitution. Inevitably, when the court is enforcing the Constitution, then, it's going to be striking down what the government is doing. If democracy is defined as majority rule, there is no way to reconcile judicial review with democracy. It doesn't matter whether it's originalist or non-originalist. It's still the court striking down what elected officials have done. More profoundly, I believe that Bickle's critique, constitutional theory ever since, is based on a false definition of democracy. Bickle, Ely, and many others have said democracy means majority rule. But I don't think that's correct in terms of the United States Constitution. The framers of the Constitution were deeply distrustful of majority rule. Think of the institutions of government they created. The president, not chosen by popular vote, but as we all know so well, by the Electoral College. The United States Senate, as it was originally devised, it was state legislatures that chose senators. But even beyond that, 2 senators per state means that the Senate isn't in accord with majority rule. During the first 2 years of the Biden presidency, remember there were 50 Democratic senators and 50 Republican senators? the 50 Democratic senators represented 42 million more people than the 50 Republican senators. That can't be reconciled with democracy's majority rule. And of course, justice of the Supreme Court and of the Federal Court of Appeals and the District Court are chosen by the President, confirmed by the Senate. That's not majority rule. And so, democracy in the United States isn't majority rule. It's a constitutional democracy. And therefore, judicial review that's enforcing the values of the Constitution should be regarded as consistent with democracy. So if the Supreme Court enforces separation of powers in the Constitution, it's furthering our constitutional democracy. If the Supreme Court, other courts, are enforcing due process of law and equal protection, it's not at odds with our constitutional democracy, but furthering our constitutional democracy. And so in this way, I think, trying to reconcile judicial review with democracy is not only a futile quest, but an undesirable one. The other goal that Bickle sets out, that scholars continue to argue for, is the desire to make sure that judicial decisions aren't a product of the values of who's on the bench. This, too, is a futile quest. The reality is that especially in the controversial matters that come to the court, the decisions inevitably are very much a product of who are the justices. There are many reasons for this. They're likely familiar to you. One, of course, is that the Constitution is written in very broad, open-textured language, and there is no history that will determine the meaning of those provisions. The history is far too disputed to provide conclusive answers. Let me give you a couple of examples and then draw conclusions from them. Let me take it from the First and the Second Amendment. Take the initial words of the First Amendment. Congress shall make no law. As I like to tell my students when I teach First Amendment law, that's false. The First Amendment isn't limited to Congress. The First Amendment includes the executive. It includes the courts. It includes state and local governments. And no one believes that no law means no law. Of course, there can be laws against perjury or extortion, blackmail, and other things that are about speech. Take the Second Amendment as an example. It says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That language is inherently ambiguous. Is it just about a right to have guns for militia service? Or is it about a right of people to have guns for the sake of security? From 1791 to 2008, it was interpreted as the former, only a right to have guns for militia service. In 2008, in District of Columbia v. Heller, the court said the latter. It's a right of people to have guns for the sake of security. In Heller, Justice Scalia wrote a persuasive argument that the original meaning of the Second Amendment was right of individuals to have guns for security. Justice Stevens wrote a persuasive dissent based entirely on history that the Second Amendment was just about a right to have guns for militia service. The reality is always, the history is ambiguous. The history can be used to support either side, either conclusion. Does it surprise anyone in this room that the 5 conservative justices took the gun rights position that conservatives favor, and the 4 liberal justices took the gun regulation position that liberals favor? The text, the history were ambiguous. I could go through any constitutional provisions and make the same claim. What's cruel and unusual punishment? What's equal protection in the law? If you wanted to focus on framers' intent, so many were involved in the drafting and ratification of the Constitution, it's a myth to say there's an intent that's out there to be discovered. And if we're going to focus on original meaning, it assumes that there was a settled meaning. I think the late Judge Patricia Wald said this best, that this kind of historical analysis inevitably is like people going to a cocktail party and they look for their friends. People read the historical record to find support for the conclusion that they always want to come to. There's another reason why constitutional interpretation is inherently about the values of the just and judges, and I'll call this the problem of abstraction. For any constitutional provision, it can be stated in what's about in many different levels of abstraction. take the Equal Protection Clause of the 14th Amendment. One way of viewing it, the most specific level of abstraction, it was intended to protect the formerly enslaved individuals. Another way of looking at it is meant to protect those of African descent, race that have been subjected to discrimination since the first days of the country. Another way of thinking of it is it's meant to protect racial minorities more generally that have been subjected to discrimination. Another way of stating would be it's meant to protect any group that's been historically disadvantaged and discriminated against. Or another is to say it's to protect any person from arbitrary treatment of the government. Now, the choice of level of abstraction matters. Does the Equal Protection Clause apply to stop sex discrimination? Does it apply to discrimination based on sexual orientation or gender identity? If you choose one of the first levels of abstraction, the answer is no. If you choose one of the latter levels of abstraction, the answer is yes. But the choice of the level of abstraction is arbitrary. The justice, the commentator, can choose the level of abstraction that comes to the conclusion that they want to come to. Justice Scalia was fond of saying that equal protection doesn't apply to sex discrimination because that wasn't the original meaning. But that all depends on the level of abstraction chosen. In fact, the problem is that if one looks at the level of abstraction in a very narrow sense, then the Constitution leads to absurd results. At a very narrow level of abstraction, Brown versus Board of Education was wrongly decided. The same Congress that ratified the 14th Amendment voted to segregate the District of Columbia public schools. There's no indication that Congress meant to eliminate racial segregation mandated by law. At a specific level of abstraction, Loving versus Virginia was wrongly decided. Most states had laws prohibiting interracial marriage. California didn't until 1948. In 1967, when Loving was decided, 16 states still prohibited interracial marriage. On the other hand, if a constitutional provision is stated at an abstract level with regard to its goals, then anything can be justified. If we think of the Constitution in an abstract way, it's all about liberty and equality, and then there's no constraint on justices and their ability to impose their own values. A third reason why justices are inevitably going to impose their own values is that constitutional law inherently is going to require balancing. Rarely is there any right under the Constitution that's absolute. The First Amendment can't be absolute. We all know of instances where there has to be limits on what somebody can do in the name of free exercise of religion or freedom of speech. I don't think the Second Amendment can be absolute. We all accept that there have to be some regulation of guns and so on. Since at least 1937, the way in which courts have dealt with this is to articulate levels of scrutiny. So we're all familiar with, if it's a fundamental right or discrimination against a historically disadvantaged group, a suspect classification, it's strict scrutiny. The government action has to be necessary to achieve a compelling government purpose. There's intermediate scrutiny. The government action has to be substantially related to an important purpose. There's rational basis review, rationally related to a legitimate purpose. But what's a compelling government interest? For that matter, what's a legitimate government interest? One of the things that I think my students find frustrating in constitutional law is that the Supreme Court has never articulated a test or criteria for determining what's a compelling or an important or a legitimate interest. That's a value choice that the justices have to make. Take some prominent examples. Take the issue of affirmative action. The question before the Supreme Court, whether in Students for Fair Admission versus Harvard College in 2023, or Grutter versus Bollinger in 2003, or in Regency versus County versus Bakke in 1978, is do colleges and universities have a compelling interest in having a diverse student body? Do colleges and universities have a compelling interest in using race to remedy past discrimination? That's a value choice among the justices. And does it surprise anyone that the 6 conservative justices in Students for Fair Admission said that diversity is not a compelling interest and eliminated affirmative action? And the 3 liberal justices found it to be a compelling interest? They were making value choices. This is true under rational basis review. Take marriage equality in the Supreme Court's decision from 2015 in Obergefell versus Hodges. There's no doubt that laws that prohibited same-sex marriage discriminated against gays and lesbians. Opposite-sex couples could marry, gays and lesbians could not. At the very least, under equal protection, all discrimination has to meet rational basis review. So at a minimum, the question before the Supreme Court was, does the government have a legitimate interest in preventing same-sex marriage? There's no way for any court to answer that question apart from the values of the justices and the judges. Finally, I would say the reason that no theory will constrain judicial review is that ultimately the justices and the judges will come to the conclusion they want. They'll ignore the theory when it doesn't get to the result they desire. Again, I can give examples. Think of Citizens United versus Federal Election Commission in 2010. I challenge anyone to come up with a credible argument that the framers of the First Amendment meant to protect the right of corporations to spend unlimited amounts of money in election campaigns. Or take Shelby County versus Holder from 2013, where the Supreme Court, for the first time since the 19th century, struck down a civil rights law as unconstitutional. This struck down the provisions of the Voting Rights Act of 1965 that required that state and local governments with a history of race discrimination voting get pre-clearance from the Attorney General. Why? Well, Chief Justice John Roberts said, it violates the principle of equal state sovereignty, that Congress must treat all states the same. Where in the Constitution does it say that? It doesn't. And it's inconsistent with the framers' intent. The same Congress that ratified the 14th Amendment also voted to impose Reconstruction, military rule, and just on southern states. Or again, to go back to students with fair admission versus President Fellows of Harvard College. The evidence is overwhelming, as Justice Sotomayor Jackson pointed out, that the Congress that ratified the 14th Amendment meant to allow race-conscious programs. They adopted many such programs, such as the Freedmen's Bureau, but the conservative justices simply ignored that. What I'm saying to you is that inevitably the values the justices and judges will determine constitutional decision-making. That surprises none of us. The first question I want to know when I have an appellate argument is, who's my panel going to be? And I know, when I see sometimes, that I could let my dog argue the case and I have no more chance of winning or losing. And I also know there's instances, unless I screw up, I have a good chance of winning. This isn't unusual. And we all know the reality that who's on the Supreme Court makes all the difference. This isn't liberal or conservative. Why did Republicans fight so hard to block a replacement for Antonin Scalia? He died in February of 2016. But Senate Majority Leader Mitch McConnell said, we're not going to hold a hearing or a vote, because they knew who replaced him would matter. If Hillary Clinton had won in 2016 and she appointed 3 justices, Roe v. Wade wouldn't have been overruled. Students' fair admission wouldn't have come out the same way. The Supreme Court wouldn't have found that the president has absolute immunity for any criminal act taken while in office. The identity of the justices always has and always will matter. Well, this brings me to the third part of my remarks, in which I want to suggest that the search for constitutional theory over the last 6 decades has been undesirable. Now, I could say it's just been a waste of time because it's a futile quest, but I want to go further than that and suggest that it's been harmful. And one way that's been harmful is that it's put forth a very misleading narrative with regard to how judicial review is done. And that's had harmful consequences. In the summer of 2005, when John Roberts went before the Senate Judiciary Committee for his confirmation hearings, he said, justices are just like umpires. We just call balls and strikes. In June of 2024, in his concurring opinion in United States versus Rahimi, Justice Brett Kavanaugh quoted that language and said that justices are just like umpires calling balls and strikes. John Roberts and Brett Kavanaugh should be ashamed of themselves for saying this. They know that this analogy is not apt. The identity of the umpire matters relatively little. Well, maybe the umpire behind home plate has a larger or a smaller strike zone, but it's nothing like the power that justices have. It's not that the justices are simply applying the rules like an umpire in baseball. They are creating those rules. So instead of John Roberts and Brett Kavanaugh speaking to the American people honestly about what justices and judges do. They give a very misleading impression, and that has consequences. Over the last several months, every time a federal court has struck down a Trump administration action, the response from the president, from the White House press secretary, from members of Congress has been that it's illegitimate for the courts to strike down the acts of an elected president, very much invoking this notion that democracy means majority rule and courts shouldn't be imposing their own values. This has consequences. So far, 6 impeachment resolutions have been introduced to the House of Representatives against federal judges who have struck down Trump administration policies. I think it fuels the threats of violence that have been directed at so many judges. I would go further and argue that the focus on constitutional theory has been undesirable because I think it asks the wrong questions and it obscures the right questions. Let me again give a couple of examples and then draw conclusions from those examples. One of these examples is the Second Amendment. In the Supreme Court in June of 2022, in New York State Rifle and Pistol Association versus Bruin, spoke specifically about how the Second Amendment was to be interpreted. Now, one would think that if we had a court that wanted to treat the Second Amendment as a fundamental right, strict scrutiny would be used. After all, that's the test that's used for fundamental rights. But that's not what the Supreme Court said. 3 times in his majority opinion, Justice Thomas said, the Second Amendment is, quote, an unqualified command. And he said the only type of gun regulation that should be allowed is that which was historically permitted. Justice Barrett, in a concurring opinion, said, we haven't decided yet whether historically permitted means just what was allowed in 1791 or it includes what was permissible in 1868 when the 14th Amendment was adopted. But notice the Supreme Court is saying that the only gun regulations to be allowed now are those that were permitted back in 1791 or 1868. Why assume that just because there wasn't the type of gun regulation then, that the original meaning of the Second Amendment was to prohibit that from happening? I believe that the crucial question with regard to the Second Amendment, beyond its meaning, is whether there is a sufficient social justification with regard to gun regulations. Do we need, such as in Bruin, to prohibit people from having guns outside the home without a permit? The Supreme Court's inquiry obscures that crucial question, focusing instead on a misleading and even irrelevant historical analysis. But compare that to a case that came down just a few days later, in June of 2022, Kennedy versus Bremerton Schools. It involved a high school football coach, Joseph Kennedy, who went onto the 50-yard line after games and kneeled and prayed. The federal district court, in the United States Court of Appeals for the Ninth Circuit, said that this violated the Establishment Clause of the First Amendment. Up until then, without exception, the Supreme Court had ruled that prayer in public schools and at public school events violated the Establishment Clause. But the Supreme Court, in a 6-3 decision, reversed and ruled in favor of Coach Kennedy. Justice Gorsuch said, we determine the meaning of the Establishment Clause today by looking at the framers' intent from 1791. There's a different form of originalism that is often discussed now, which looks at original meaning. He wanted to go back to the Robert Bork form of originalism, looking at framers' intent. But ask yourself this. Is the inquiry really, what did the framers of the First Amendment think about a high school football coach going on the field and praying after games? But here what the Supreme Court is saying is, unless there's an indication that the framers meant to prohibit something, it's allowed. Bruin was on a Thursday, Kennedy was on Monday. In Bruin, they're saying that the only type of regulation to be allowed is that which was allowed in 1791. In Kennedy, they're saying the only thing that's prohibited is that which was prohibited in 1791. That seems very inconsistent. It seems manipulating the method of constitutional interpretation to get to the result they want. But my point is more general than just the examples of the Second and the First Amendment. My point is that constitutional law should always be looking at the underlying values to be served by a provision and how they apply in modern circumstances. Focusing solely on what was thought in 1791 obscures the right question, and it leads to undesirable consequences. Well, this then leads to the fourth and final part of my remarks. What does it mean to have constitutional law without constitutional theory? It might sound radical, and yet for most of American history, there was constitutional law without constitutional theory. Justices, judges, academic commentators looked at a myriad of different sources. To be sure, all liberal and conservative start with the text of the Constitution. But as I said, and as we know, rarely does the text provide answers. It's certainly worth looking to see what did the framers think, what, with regard to the original meaning, if we know it, was it? That doesn't mean it's determinative. It doesn't mean that it's controlling, but we should at least be aware of what they thought. What about precedent? What does it tell us? Precedent's important. It provides stability in the law. It helps with regard to legitimacy. What does tradition tell us? And what do modern social needs tell us with regard to the meaning of a constitutional provision? I readily admit that looking at a number of different sources doesn't lead to determinate results. It's inherently indeterminate. But long ago, the legal realists taught us that formalism is impossible, that it's not possible to start with premises and reason to determine conclusions, that after all, outcomes very much depend upon the values of those who are involved. Maybe it might be said that in order for the courts to have legitimacy, we need to have the myth that formalism is possible. I reject that. I think most people know that Roe versus Wade was overruled not because of the method of constitutional interpretation, but because Donald Trump was able to appoint 3 people to the Supreme Court. People know that Grutter versus Boland was overruled, not because of the method of constitutional interpretation, but because of the conservative majority on the court. I don't think we need to pretend that the emperor has clothes in order to maintain the legitimacy of judicial review. In 1989, I had the great honor of being asked to write the foreword to the annual issue of the Harvard Law Review, something Khiara did just a few years ago. It too is like being elected to a Hall of Fame. And I concluded my Harvard foreword by writing, and I go back to those words now with regard to the conclusion to my remarks. I said in November of 1989, Supreme Court justices have discretion in deciding cases, and the choices they make will be a product of their values and views. If the court overturns Roe versus Wade, it will be because a majority of its members do not believe that a woman's right to choose is sufficiently important to restrict the authority of state legislatures to decide the issue. In other words, constitutional law now and always is about values. The critic's task to expose and identify the value choices that the court is making and to explain why the court's rulings are undesirable. Inevitably, much of what looks like a difference in approach is really a disagreement over substantive goals. It's no coincidence that advocates of judicial review based on original intent were conservatives who disagreed with the substance of the Supreme Court's ruling. I have argued against constitutional theory. It's been done for over 60 years. But there could be a different form of constitutional theory, one that focuses on the values. What should they be? How should they be applied? And I hope that maybe that will be the focus of constitutional theory, a very different form of constitutional theory for the next 60 years. Thank you.
Well, I want to begin by saying thank you to Tom Jorde for bringing us together and John Cowell for being the engine behind today's event, and of course to my dean. So proud to have a dean as amazing as Erwin Chemerinsky for writing a brilliant paper that was the source of today's lecture. So I find Erwin's analysis to be unimpeachable, and I agree with practically every point that he makes in this lecture. Thank you. So I agree that there is no such thing as political neutrality in constitutional interpretation. Like Erwin, I do not believe that it is possible for a theory of constitutional interpretation to be devoid of political values. I believe that despite its protestations, originalism has political values baked into it. To be sure, the choice to attempt to interpret the Constitution in light of the imagined meaning of the document in the late 18th century or mid-19th century is itself a political choice. This is far from the only political choice made within originalism. There is the political choice of selective originalism. That is, it is a political choice, for example, to invoke the original meaning of the Constitution when interpreting the constraints imposed by the Due Process Clause vis-a-vis abortion and Dobbs. And it is a political choice not to say a word about the original meaning of the Constitution when interpreting the constraints imposed by the Equal Protection Clause vis-a-vis race-conscious college admissions programs and Students for Fair Admissions versus Harvard College. And then there is the political choice within original public meaning originalism of purporting to be interested in the understandings of the Constitution held by the public, a community that includes the enslaved child and the indigenous woman and the indentured servant as much as it includes the propertied elite. But the practice within this branch of originalism of reducing the public down to wealthy white males generally, and then down to Alexander Hamilton and James Madison and Benjamin Franklin, Thomas Jefferson, George Washington, and John Adams specifically, and then interpreting the Constitution in light of the understandings of these 6 men, that is a political choice. There is also the political choice within original law originalism of claiming that the founders' law is our law, but then denying the fact that there are many instances in which the founders themselves disagreed with one another. That is, it is a political choice to say that we are bound by the founders' law, but then to obscure the reality that on a host of issues, there is no founders' law. Instead, there is only contestation amongst the founders about what the law should be. So again, I believe that originalism has political values baked into it, but I should be as clear as day. I also believe that any non-originalist constitutional theory, like living constitutionalism or popular constitutionalism, non-originalism also has political values baked into it. Indeed, the choice not to attempt to interpret the Constitution in light of the imagined meaning of the document in 1787 or 1791 or 1868 is itself a political choice. It's essentially giving Jean-Paul Sartre, there is no exit. So I agree with Erwin that in light of the inevitable presence of political values within constitutional interpretation, judges should just be honest about what they are doing. As Erwin says, there should be more candor in constitutional theorizing. When judges admit to the values that they have consulted when creating law and deciding cases, they are likely to feel the need to defend those values. We can then have honest debates about competing values. This, of course, is light years away from what originalists have been doing on the court. They have been hiding behind the claim that the people, that is Thomas Jefferson and James Madison, decided today's most contentious legal issues back in 1787 or 1791. So a question that I just want to explore in my short remarks is why there is so little candor within constitutional interpretation and specifically originalism. Why are originalists hiding the ball by denying that political values are part and parcel of their preferred approach to interpreting the Constitution? I see 2 possibilities. The first possibility is that they do not know that political values are part and parcel of their preferred approach to interpreting the Constitution. Consider Bruin, for example. In Bruin, the court said that only those present-day regulations, gun regulations that are analogous to gun regulations that existed during the late 18th century or early 19th century, are permissible under the Second Amendment. Okay, so we're searching for analogies. Then when holding that it is unconstitutional for states like New York to have laws that allow regulators some discretion around whether to issue an applicant a license to carry a gun outside of the home, Justice Thomas, who wrote the majority opinion, essentially looked through the historical record and found his friends. That is, Justice Thomas found laws from the late 18th century and mid-19th century that permitted people to carry guns and other weapons in public to be constitutionally significant. Those ones counted in terms of constitutional interpretation. And then he found other late 18th century and mid-19th century laws that disallowed people from carrying guns and other weapons in public to be constitutionally insignificant. Those didn't count. So the claim that there is no candor within originalism because originalist justices are unaware that political values are motivating their interpretations of the Constitution would propose that Justice Thomas simply had no idea that his political values were causing him to privilege permissive gun regulations and discount restrictive gun regulations. And I just don't find that account to be plausible. I think that account suggests that we law professors are smarter and more insightful than the originalist justices. It suggests that we legal academics know something that they don't know. And I just don't think that is true. I think that on the whole, yeah, the justices are a pretty smart bunch. They know what we know. So if originalists lack candor about the political values that motivate their interpretations of the Constitution, not because they don't know that political values are motivating their interpretations of the Constitution, well, then they do know what is motivating them. They're just not saying it. And this explanation for the lack of juridical candor seems a little more deceptive and deceitful because we have to conclude that originalists are hiding the political ball knowingly. And why would they do this? And I think that the answer has something to do with perceptions of institutional legitimacy. Let's return to Dobbs. The majority claimed that it was an exercise in political neutrality to reverse a half a century of precedent and to interpret the Constitution as agnostic on the question of whether governments can criminalize abortion. And Justice Kavanaugh got obsessive with this claim in his concurrence. Indeed, Kavanaugh's concurring opinion repeats neutral or a variation of the word 13 times over the course of a 12-page slip opinion. On the question of the moral significance of the fetus and the consequences that the fetus's moral status should have on the ability of the gestating person to decide whether or not to carry the pregnancy to term, Kavanaugh said, quote, "The Constitution is neutral and leaves the issue for the people and their elected representatives to solve through the democratic process in the states or Congress." Instead of adhering to the Constitution's neutrality, the court in Roe took sides on the issue and unilaterally decreed that abortion was legal throughout the United States up to the point of viability. The court's decision, he continues, today properly returns the court to a position of neutrality and restores the people's authority to address the issue of abortion through the processes of democratic self-government established by the Constitution. That's 3 out of 12 mentions of the word neutrality. It deserves underscoring that it is not a demonstration of neutrality to interpret the Constitution in this way. When the Constitution contains a guarantee of liberty, and when there is 100 years of precedent interpreting that term to protect the individual from state intervention in matters involving the family, as well as close to 50 years of precedent interpreting this term to protect the individual right to terminate a pregnancy, it is not neutral to interpret that term as silent on the question of abortion rights. Indeed, it is a non-neutral interpretive act that permits the court to take a side in the abortion debate. The court has sided with those who believe that it is acceptable to force birth. So why? Why did the 5 justices who signed the majority opinion feel the need to announce that they were being neutral? Why did Kavanaugh feel the need to repeatedly declare the court's neutrality, even when only the most naive or gullible amongst us will believe his protestations about neutrality? And I think it is all about perceptions of institutional legitimacy. We have been asked to pretend that the judiciary is the apolitical branch of our government, even while we observe the most political contest when it comes down to composing the court. We observed Senator Mitch McConnell's refusal to hold Senate hearings on Merrick Garland's nomination to the Supreme Court at the tail end of the Obama presidency in order to prevent the appointment of a liberal justice who, among other things, would be likely to vote to affirm Roe. We observed that one of Donald Trump's many campaign promises during his bid for the presidency in 2016 was that if elected, he would appoint justices to the court who were willing to overturn Roe. We knew that Justice Gorsuch was confirmed by only 54 votes after McConnell abolished the filibuster for Supreme Court nominees because Democratic senators recognized that Gorsuch was a fulfillment of Donald Trump's campaign promise. We observed the bitter fight over Justice Kavanaugh's confirmation to the court, knowing that he secured only one Democratic senator's vote in his favor, not solely because credible allegations of sexual assault had been made against him, but also because Democratic senators knew that it was likely that he would vote to overturn Roe if given the opportunity. And finally, we observed the hasty nomination and confirmation of Justice Barrett after Justice Ginsburg's death some 6 weeks before the 2020 presidential election, knowing that Republicans sought to install a conservative supermajority on the court that would be willing to shape the country in line with the Republican Party's vision, including on the issue of abortion. And so we know that the court's decision in Dobbs is a political strategy that has come to fruition. It is made possible by politics. It is the materialization of political commitments. That Dobbs and Bruen and Students for Fair Admissions and Kennedy versus Bremerton School District and Trump versus United States and all the cases decided on the shadow docket, that all of these cases are acts of political will, calls the legitimacy of the court, which is squarely affixed in the purportedly apolitical branch of government, these cases with political values infused into every letter of the majority opinions, call the legitimacy of the court into question. Justice Sotomayor raised this issue during oral arguments in Dobbs. She observed that the sponsors of the Mississippi law banning abortion after 15 weeks of pregnancy said quite openly that they sought to pass this law so that they could ask the court to overturn Roe, quote, because we have new justices on the Supreme Court. And if the court accepted the invitation to overturn Roe, Justice Sotomayor asked at oral argument, she said, quote, will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts? She continues, I don't see how it is possible. If people actually believe that it's all political, how will we survive? How will the court survive? End quote. The Dobbs majority's declaration of its neutrality and originalism's lack of candor as a general matter suggests that this is how it thinks the court will survive. It will survive by asserting that political commitments do not motivate it when they obviously do. It will survive by declaring its neutrality when the evidence unambiguously disproves the claim. And so I do think that we desperately need candor in constitutional interpretation, but we are only going to get there when the fact that constitutional interpretation is a value-laden enterprise does not sit in tension with the court's legitimacy. That is, we are only going to get candor from the court when the people understand that the court does not become illegitimate when it interprets the Constitution in light of political values. And this is true because such a value-laden enterprise is inevitable. We can start by ceasing to call it the apolitical branch of government. And we need to create the discursive terrain on which people understand that a legitimate court is not one that is immune from political values, but rather is one that is honest about the political values that infuse it. Thank you.
Well, two amazing presentations. What a great event. I just want to thank the Brennan Center, Berkeley Law, Alexandra and her colleagues at the California Law Review, Tom, Jorde, for helping bring this event into being. I think it's really important that this is an event sponsored by the Brennan Center. Justice William Brennan, of course, was indisputably one of the most influential justices of the post-war period. Perhaps Earl Warren was just as influential, and maybe Justice Scalia has been as influential as well. Justice Brennan is the principal architect of one of the most important positions in American constitutional theory. His position is called contemporary ratification theory. Justice Brennan believed that the court should consider itself bound by the constitutional text, but he disagreed with originalists because he believed that the relevant meaning was the contemporary meaning of the text for the American people. It's really a pleasure to be on the podium with my old friend, Erwin Chemerinsky, a great scholar, an important figure in legal education, and maybe above all else, I don't know if he sees it this way, an incredible advocate. The skills that I saw more than 50 years ago in classrooms where academic debates were held were on display today. It is no surprise that Erwin has been one of the most influential figures in contemporary law. Now, I have some disagreements. And I have to say, I think you'll see more disagreement at the next iteration of this event. For better or worse, we have three political progressives on the podium today, but there will be a conservative at the next iteration of this event. But there is nonetheless a lot of disagreement. So Erwin is against constitutional theory, and I'm for it. So why do I say that? Well, to answer that question, we need to know something about what constitutional theory is, and in particular, what normative constitutional theory is. So normative constitutional theory addresses questions about what we should do in constitutional context. And it addresses those questions theoretically on the basis of reflection, careful thought, and an attempt to develop principles and methods. The questions that constitutional theory address include first-order questions. These are questions about what the constitutional rules and standards ought to be with respect to important questions, like the right to abortion, or the scope of the freedom of speech, and so forth. But it also addresses second-order questions. These are questions about how constitutional decisions ought to be made. What should the role of the courts be? What should the role of Congress be? What role, if any, should the president have? What methods are appropriate for making constitutional decisions? Second order questions are really, really important. Why? Because we are a pluralist society. We have very different beliefs about religion, about morality, and about politics. So it makes a difference what institutions make constitutional decisions. And it makes a difference, an important difference, how those decisions are made. Now, if you thought that the role of constitutional theory was somehow magically to force the Supreme Court to act in certain ways, then constitutional theory would be very disappointing. No theory can make the judges decide cases in a particular way. Theories are things that academics and sometimes justices come up with, but they can't force compliance. The constitutional system obviously includes important inputs from political actors who select the justices, and so it's not going to be the case that what a theory can do for us is to make the Constitution work in a particular way. What can constitutional theory do? Well, one thing it can do is provide a standard for criticism and evaluation. Constitutional theories can focus on questions about whether the judges and justices are doing a good job or a bad job. And it's not just justices and judges, because Congress has constitutional duties. And we can use a constitutional theory to criticize Congress. The president has constitutional obligations. And we can use a normative constitutional theory to criticize the actions of the president. Constitutional theory can do another thing. It can change our sense of what is possible. So James Bradley Thayer, writing in 1893, suggesting a much more restrained role for judges and a much greater role for democratic institutions in the constitutional process, opened what we sometimes call the Overton window. He opened the set of possibilities in an important way. And of course, the idea of deference, that Congress should receive deference from the Supreme Court, emerged in this period. That's what progressive constitutional theorists were arguing for in the 19-teens, in 20s, and for a brief period of time, it became the dominant approach on the Supreme Court, especially in the 1940s, when there were 9 New Deal justices on the court. Now, things changed during the Warren Court, and I want to talk about that a little bit later. What is constitutional theory today? What are the options? What's being debated? And I just want to say that I see the picture of constitutional theory, the narrative of constitutional theory, quite differently than the way Erwin sees it. It's a commonplace among constitutional theorists in 2025 to say we are in the post-counter-majoritarian difficulty era. That debate, the debate of the 1960s about the counter-majoritarian difficulty, it's just not the debate we've been having for the last 40 years or so. Certainly not the debate we're having in 2025. So what are the options that people are thinking about today? Well, one of them is clearly public meaning originalism. I hope I have a little time to talk about that. But the most common approach to constitutional theory in 2025, the approach that is most discussed in the academy, is called constitutional pluralism. And it's Erwin's approach. It's exactly Erwin's approach. Erwin is not against constitutional theory. He's against a bunch of things. He's against Alexander Bickle's analysis of the fundamental problems of constitutional law. He's against originalism, but he's very much in favor of constitutional theory. Unless, now Erwin's very persuasive, and maybe this is the maneuver that's coming, unless he defines himself out of constitutional theory by saying if you're a pluralist, you don't have a constitutional theory. If he does that, he's using the phrase constitutional theory in a radically different way than most constitutional theorists do. Another position that's very important today is concerned about majoritarian democracy. So these days, you hear people arguing for a position that certainly was not popular in the 1960s and 70s or 80s, and that's for the complete abolition of judicial review on constitutional issues. Lots of theorists are taking this position. Sam Moyn at Yale Law School, Nick Bowie at Harvard, Ryan Dorfler, who also is at Harvard. In fact, you might put it this way: all the cool kids are arguing for the abolition of judicial review. A lot of what Erwin was talking about concerns questions about constitutional possibility. What is possible in the constitutional realm? And in a sense, Erwin seemed to be arguing for something that I just can't believe that he believes in his heart of hearts. He seemed to be arguing for constitutional determinism, for the idea that our constitutional practice can't respond to principled arguments about what judges ought to do, that our constitutional history is already set in stone by the political forces that will select politicized judges who will engage in political decision-making. Well, now this is a very complicated topic, right? What are the forces that shape constitutional law? I just want to say two things that I believe. One is that Americans may well be blinded by our particular and peculiar constitutional history. That when we look to other constitutional cultures, we see a range of possibilities. Some constitutional cultures actually are very formalist. Other constitutional cultures are way more political than we are. In many other constitutional systems, outcomes are determined directly by what will benefit the regime or the party in power. Judges actually vote for lawyers who belong to the right political party, irrespective of the constitutional issues. So there, in my view, constitutional possibilities are not set in stone. They are something we create, that we make happen through human choice. And deep pessimism about constitutional possibilities is disabling. And if you are going to be a pessimist, if you are going to argue that the causal forces restrict the possibilities for constitutional change, don't apply a double standard. Don't say, well, when it comes to the way I think things should go in the world, the Constitution I want, I get to imagine the ideal Constitution. And I get to advocate for a Supreme Court that would decide cases in accord with what I believe are the right constitutional values. But when it comes to originalism or a strong view of precedent or some other theory with which I disagree, then determinism sets in, and those real originalism just won't happen. I would like to suggest something that I think is disturbing, and I also believe that it's very hard to hear, and even harder to think about and sort of evaluate in a deliberative way. I would like to suggest that progressives and liberals made a mistake, a grave error, when they endorsed constitutional pluralism and other approaches to constitutional law that gave judges the ultimate say-so about our constitutional order. Now, it's an understandable mistake, and it's a mistake I made as a younger scholar. So it's an understandable mistake because if you look at the world, and in particular the Supreme Court, as it was constituted in the 1960s and the early 1970s, you could imagine that the Supreme Court would always be deciding cases in accord with progressive and liberal interpretations of constitutional values. But things changed. Things changed. I began to be very worried about my own views about constitutional law around 1990 or so. We now have a Supreme Court with 6 justices appointed by Republican presidents and 3 justices appointed by Democratic presidents. In 1990, there were 8 justices appointed by Republican presidents and 1 justice, Justice White, hanging on from appointment by President Kennedy in the early 1960s. And I said to myself, wait a second. I believe that the Supreme Court ought to be deciding cases in accord with constitutional values. Now, the particular version of the theory that I believed in was Ronald Dworkin's moral readings theory. But in this respect, it's very much like constitutional pluralism. And then I said to myself, well, wait a second. Do I believe that the current Supreme Court majority ought to be deciding cases in accord with their understanding of constitutional values, as opposed to legal constraints, like stare decisis, and like the actual meaning of the constitutional text? I just was absolutely thrown for a loop and didn't know what to think. And gradually, over a period of about 10 years, I decided that it would be better if the Supreme Court were to actually do what the Constitution says. Now, that's originalism. But people make a lot of mistakes about originalism, and I can't mention them all now because I have only 41 seconds left. But here's one mistake. It is to equate originalism, the theory, with the Roberts Court. And that is clearly a mistake. It's clearly a mistake because, first of all, only 2 or 3 justices on the current court can reasonably be described as originalists. Chief Justice Roberts is not an originalist at all. He completely rejects originalism and is quite worried about it, and therefore assigns very few important opinions to originalist justices. Brett Kavanaugh is a constitutional pluralist, but not Erwin's kind. He's a constitutional pluralist who looks to the backward-looking factors only, to precedent, tradition, history, constitutional structure, not to constitutional ideals like equality. Sam Alito calls himself a, quote, practical originalist. What does that mean? It means that Justice Alito thinks that it's perfectly okay to depart from originalism on the basis of his own constitutional values. I do not think it is a good idea to send the Supreme Court the message that what they ought to be doing is deciding on the basis of their values. It looks great when you agree with a majority of the justices, but if you, like many in the room, I'm sure, disagree with the values of 6 of the current Supreme Court justices, you ought to be very worried about the idea that they are doing the right thing when they decide cases not on the basis of precedent or text, but on the basis of their interpretation of constitutional values.
I want to thank Khiara and Larry for their wonderful commentaries. As I read the schedule, I get a few minutes to quickly respond. Let me be clear, my overall position is society is better off with an institution largely immune from direct majoritarian control to give the Constitution meaning and apply it to current circumstances. Now, perhaps we could call that a constitutional theory. My only point is it's quite different than constitutional theory has been, at least since the time of Alexander Bickel. To me, what the conversation should be about is, what are the values that the Constitution is seeking to achieve, and how do we go about accomplishing that in modern circumstances? Obviously, Khiara and I are very much in agreement. I just want to raise one thing that she says at the end that I think very much poses the question. She says, we shouldn't pretend that the court is, quote, an apolitical branch of government. I think we need to talk about what we mean by political more precisely. In one sense, the court isn't political. The justices aren't elected, and they'll never face election. The justices can't be lobbied in the same way that any legislator can be lobbied. The justices, as far as we know, don't trade votes. So in that sense, it's not political. But if we mean, are they making decisions based on their values? Of course they are. Marbury versus Madison wouldn't have come out the way that it did if John Marshall didn't have a particular view with regard to judicial review. With regard to the Lochner era, decisions wouldn't have come out that way, but for the conservatism of the majority of the court. The Warren Court was about the values of the justices, and obviously now the Roberts Court is about the value of the justices. We shouldn't pretend that it's been about something other than that. So it's not political in one sense, but it is very much about values and always will be. Obviously there's more disagreement between Larry and me, but I'll be very brief. First, I don't agree with him that we're post-counter-majoritarian difficulty. Read the majority opinion in Dobbs that Khiara talked about, and how much Justice Alito's opinion is about the need to defer to the political process to make the choices. Read Justice Kavanaugh's concurring opinion that I mentioned, United States versus Rahimi, where he says there's only 2 ways for judges to decide, either to follow history or to impose their own values, and the latter has to be illegitimate. Or look at the contemporary literature with regard to originalism. Originalists defend it in terms of the need to reconcile judicial review with democracy, and the need to avoid judicial value imposition. So I think that the very premises that Alexandra Bickel was working for continue very much to haunt constitutional law. Obviously, I believe in constitutional pluralism, but I think it's quite different from the method of interpretation of Bickel or Weschler or the originalists today. Second, Leary says that I'm arguing for constitutional determinism, and I don't understand how he could get that from what I'm saying. I think that the decisions on the court are a product of who's there. It's their life experiences and their values. That doesn't make it determinate. Every time I argue a case in the Supreme Court or in any court, I always believe I'm going to win, no matter who the justices or judges are. But I'm also enough of a realist to know the ultimate outcome is likely going to depend on who those judges are, far more than it's going to depend on my advocacy. So I don't believe in constitutional determinism. And the final point I want to respond to is I think Larry's very powerful argument. Do we want at this moment in time to give the court the power to impose its own values? One of the key points I was making is the court has that power, is going to do so whether we want to acknowledge it or not. We don't gain anything by pretending that they don't have that authority. But I also believe that at this moment in time, the survival of our constitutional democracy is going to depend on the United States Supreme Court. It's going to depend on their forcing the values of the Constitution against the Trump administration. We have never seen a challenge to democracy as we witnessed since January 20th. The repeated lawlessness, the attempts to aggrandize executive power, the use of authority for retribution. And I think if the court is just originalist in dealing with this, it's going to grant the Trump administration far too much power. Then instead, what it needs to do is what I've been arguing for: identify the values that the Constitution is meant to achieve. Separation of powers, protection of individual liberty, equal protection, and enforce those values today. We're not going to find the answers in originalism. We can find it in the values of the Constitution if the Supreme Court will enforce them.
Shall we open it up to questions from the audience? Oh, yeah.
Thank you all. This was really, really fantastic. So glad to be here. So Professor Solum put on the table a question of we're in a pluralist society and it matters which institutions act to answer certain value judgments. And I just wanted to provide Dean Chemerinsky a chance to respond to that. Is there something there about the relationship between democracy and the Constitution, about which institutions act, that you think is important?
I think it goes to what I said a moment ago in my response, that ultimately I believe that we as a society are better off having an institution like the judiciary give meaning to the Constitution and apply it. It's why I respond very negatively to those that Larry identified would eliminate judicial review. Some of this is the answer that comes from Marbury versus Madison, that John Marshall said, the Constitution is meant to limit the government, and those limits only have meaning if they're enforced. The reality is that the elected branches of government have all sorts of incentives to not follow the limits of the Constitution. It comes from my own experience. I've spent a lot of time as a lawyer representing individuals who have no chance of success in the political process. I filed the first lawsuit on behalf of the Guantanamo detainees in January of 2002. I represented a homeless man in the United States Supreme Court. I've argued several death penalty appeals. Go on with examples of this, victims of police abuse. These are individuals who may not win in the courts, and I've lost more cases than I've won, but they have no chance of winning in the political process Congress surely was not going to adopt a law protecting the rights of the Guantanamo detainees. It's just the opposite. Unhoused people don't get protection from the political process, as we've seen from the Supreme Court in its decision in Grants Pass, where it upheld what the political process was doing to the unhoused. States don't give more rights to criminal defendants. When's the last time you saw a legislature expand rights for criminal suspects or for prisoners? So my answer is, we need the court to enforce the values of the Constitution, because it's often judicial review or nothing. And that's why I concluded as I did. I think with regard to the Trump administration, the check's not going to come from the people around Donald Trump. Kash Patel and Pete Hegseth and Pam Bondi aren't going to say no. Congress isn't going to say no. If the Constitution is being enforced, it has to be through the courts.
The Constitution is not written in a cohesive register. There are parts of it that are capacious and abstract, or when you were talking about the First Amendment or equal protection. There are other parts that are quite specific and prescriptive, like Section 1 of Article 3, Clause 3, that every state gets 2 senators. My question is, what is the value of maybe one constitutional theory, when I think we all have different constitutional theories when we're dealing with a particular text and provision, given that the Constitution is different registers? And do we need a vocabulary that shifts based on where we are in the Constitution?
I don't think so. I'll be interested in what Khiara and Larry say. If the text is clear, then I think everyone would say, follow the text. The president has to be 35 years old. Maybe we could come up with a hypothetical where that would be at issue. But even provisions of the Constitution that seem to be clear often aren't. The Constitution says the president has to be a natural-born citizen. Well, Ted Cruz was born in Canada. Does he fit within that? It's a matter of interpretation. I mean, it's absurd, but you could also say, is somebody born by cesarean section or where the mother had anesthesia? Is that natural-born citizen? I give that just as an example that you have to interpret the words of the Constitution. I would say, putting aside the rare instance where the text of the Constitution is clear, inevitably it's interpretation, and the interpretation should always be about identifying the values we serve and talking about how to achieve them here. And I'll give another example. I think Section 3 of the 14th Amendment is clear in saying that those who participate in an insurrection are disqualified from being president after they take an oath of office. And I think the Supreme Court just abandoned the literal text of the Constitution to come to the political result it thought expedient. So no, I don't think we need to have different constitutional theories.
I agree that I think that when we talk about constitutional theory, we're actually talking about those parts of the Constitution that are capacious, that there is some ambiguity, right? So again, 2 senators per state, pretty clear, but what does, due process of law mean? What does the equal protection of the laws mean? What does a well-regulated militia mean vis-a-vis the right of the people to keep and bear arms? So I think when we are talking about constitutional theory, we are talking about those parts of the Constitution that are subject to interpretation. There are many parts of the Constitution that seems, clear as day, but then as Erwin just mentioned, somehow the justices have found ways to insert ambiguity and unambiguous language.
So absolutely true that there are some constitutional provisions that don't fully determine their application. No one could deny that. I want to say, though, that if you actually examine the history, some constitutional provisions that today seem to us to be radically indeterminate or underdeterminate, actually, when they were written, had very clear and specific meanings. Let me just take an example. The due process of law clause of the Fifth Amendment to the Constitution. So the Supreme Court, of course, starting somewhere early in the 20th century, and continuing until today has glossed due process of law as fair procedures, right? Well, there is absolutely no support for that reading of the provision in 1791 when the Due Process of Law Clause was written. I was quite surprised by the research that I did with a brilliant historian, Max Kramer, that leads me to make this assertion quite confidently. The phrase due process of law in 1791 referred to what we still call legal process, as in service of process. It was a requirement that courts issue legal process before a legal proceeding that could take someone's life, liberty, or property was initiated. And it applies to legal process of various other kinds. The fair process interpretation is a 20th century invention. If the meaning of due process were fair process, then, of course, we would have a levels of generality problem, and a problem that different justices would have different ideas about what's fair. But the actual original meaning of the Due Process Clause is very determinate. Likewise, the natural-born citizenship qualification for the president. Now, that provision is subject to some historical dispute, and that dispute might be relevant to people like Senator Cruz, who were born outside of the United States. There's a debate, right? And I just want to say, debatability should not be the criteria for whether or not the meaning of a constitutional provision is clear. Debate can exist on all kinds of issues where one side of the argument is clearly stronger than the other, better accounts for all of the evidence of the original public meaning than another. And this is exactly the case with respect to the natural-born citizen clause, where there is very good originalist scholarship, and it concludes that you are a natural-born citizen if you are a citizen at the time of your birth. And I just want to complain, Erwin, no one can make a plausible argument that the natural-born citizen clause applies to natural birth as opposed to cesarean section. I know it was a joke.
It was.
But it's not really, it's not really a joking matter, is it?
Let me quickly and respectfully disagree. In terms of due process, I do disagree with that. I think if you look at the Magna Carta and talk about what the Magna Carta spoke of due process, it had a notion of fair process. You can go back earlier than that. You can go to the Torah. If you look in my office, if you come visit me, I have a quote that says, "Justice, justice, thou shalt pursue." And the question was, why is the word justice used twice there? And commentators have said, because there should be justice in the sense of fair process and justice in terms of fair outcomes. So I think if we had more time, we could debate whether or not the meaning of due process is nearly as clear as you say. But of course, that begs the question. Even if you were right, why does that tell us that's what it should mean today? With regard to natural-born citizen, you're right. I was coming up with an absurd example to show that even words that seem clear to us could have ambiguity. I will agree that it wouldn't be a plausible interpretation of the phrase.
I just want to just jump in and just add that when you said, Larry, that the original meaning of the due process clause is clear, there's this part of my brain that disagrees with everyone. And it said, clear to whom? And in my remarks, I just mentioned, the indentured servant and the indigenous woman and the enslaved child. And I find it hard to believe that the indentured servant and the indigenous woman and the enslaved child would believe that the due process clause of the Fifth Amendment meant the same thing as the people who we tend to privilege their understandings, like Alexander Hamilton and Thomas Jefferson. So I think there's even ambiguity in something that you believe to be fairly determinate.
So I want to take a cheap shot now. Erwin, the words due process do not appear in Magna Carta. There is the phrase due process of law. I mean, I've written an article about this that traces the history exhaustively from Magna Carta through today. Those words do not appear in Magna Carta. Now, it's perfectly understandable that Erwin would think, well, they must be there because Magna Carta was all about procedural fairness, and isn't that what due process means? But the answer is no. The words are not there, and they had a very specific meaning that's quite different than the modern conception of due process. I just want to say that we can debate about originalism doing armchair originalism, right? Armchair originalism, we take our linguistic intuitions about the meaning of the words and sort of the skills we learned in law school for disputing the interpretation of a legal text. And then we argue that the Constitution is radically indeterminate because we can make arguments that it is from our armchair without doing any research. That's bad originalism. And the Supreme Court does bad originalism all the time, and many times it doesn't do originalism at all. Dobbs was not a decision reasoned on originalist grounds. Kennedy was a decision without any careful consideration of original meaning. The role, for me, of originalist theory is to provide ourselves with the tools to make careful criticisms, not just of constitutional pluralism, but also of bad originalism when it is so practiced by the Supreme Court.
It's so tempting to respond, but I'll let you get the last word, because the instructions that John Cowell gave me say, and I quote, Erwin Chemerinsky offers brief closing remarks and invites audience to reception. So with that, let me say, I again thank Tom Jorde, John Cowell, the Brennan Center. I thank Khiara and Larry for being here. I thank all of you for coming. And there's a reception, I think, in the donor lobby upstairs. Please join us. I know.